Okay, good evening, everyone, and welcome to the book launch of Orlando Scarcello's latest work, titled "Radical Constitutional Pluralism in Europe." It is a great pleasure to be here and chair this panel. Thank you so much, Giuseppe, for inviting me. It is a pleasure because I've been knowing Orlando for more than 10 years now. So, I mean, I was there when this book was first conceived and then drafted first, second time, and worked and then while Orlando was working upon it, and I know how much passion and dedication he put on it. I'm very happy that it got freshly published by Routledge. With me in the panel will be Marco Goldoni and Thomas Flynn. Marco is senior lecturer in legal theory at the University of Glasgow, whereas Thomas Flynn is lecturer at the University of Essex, and they've both published extensively in the realms of legal theory and constitutional law. So I'm sure they will give Orlando's plenty of insights on how on his work. So Orlando will give you the floor for around 20 minutes. Then will be the time for the discussants to intervene for around 15-20 minutes each. And then we will have the time for the questions and answers. So Orlando, you have the floor, please.
Thank you so much, Silvia, for chairing this event. I would also like to thank, of course, Marco and Tom for accepting to be discussants for this book launch. And of course, a big thank to all the friends of the STALS group, Giuseppe, Giacomo, for hosting this event within this series of webinar of STALS, which is always extremely interesting. And I invite, of course, all the attenders to also check out the other webinars of the series. Well, concerning the book, it is here in its hardbook version, Radical Constitutional Pluralism, Routledge 2023. I advise also to look for the paperback that has been published simultaneously and is readily available as well. The book is the ultimate outcome of my PhD dissertation at Sant'Anna School of Advanced Studies, and then of its redrafting and updating in the following years, working as a postdoc, first at Lewis and then at KU Leuven. But in the end, this book answers a question that was in my mind, if I to be fair, since I was an undergraduate student, and that is the question of how it is possible that we have in Europe the coexistence of simultaneous claims of constitutional authority. One grounded into the law of the member states in their constitutions, the other grounded into the treaties, the autonomy of EU law. And of course, the reason why I had this question in my mind is let's say twofold. One is theoretical, because of course, this is not what we teach to first-year law students, right? What we try to teach them is some vulgarized version of the Kelsenian pyramid. There is one ultimate norm on top, and then the entire legal system develops beneath it. The second is more practical. If we don't have one constitution on top, we don't have a clear settlement rule in case of conflict. So there's a theoretical reason, there's a practical one as well. What do we do in cases of conflict if we don't have clear ideas of what is on top of the system? In a sense, this is made even more problematic in the context of the EU, for this form of legal pluralism, so the coexistence of various legal systems, is made more complex by the fact that the ultimate norms are allegedly at least, of a constitutional kind, in the sense that their content is in line with the basic tenets of the dominated political ideology of modern public law, that would be modern constitutionalism. And these forces, in my view, to profess a certain allegiance to, first of all, some degree of political liberalism. So these constitutional norms must have some degree of adherence to political liberalism in the form of separation of powers and guarantee of rights in some of the many forms that these can be accomplished, and some degree of commitment to a democratic governance as well. Here, a little parenthesis. Is it fair to say that the European Union is, in the end, a constitutional system in the sense that it professes a certain degree of allegiance to modern constitutionalism? I would say that the answer is the more yes than no. A series of changes that have started probably already in the 70s, but much more clearly since the Maastricht Treaty, have enhanced the degree of consistency of EU law with at least the liberal tenet of modern constitutionalism. The democratic remains, frankly, more problematic, although progress has been made on that side as well. But for the liberal tenet, today we see in the treaties, in a series of also symbolic provisions of the treaties, a few articles in TEU, Article 2 on the values, Article 6 on rights, Article 10 on democracy, where we have a series of symbolic and also, to a certain extent, practically effective norms closing up the gap between the actual functioning of EU law and the liberal tenet of modern constitutionalism. We have the Charter, which has been embraced also by some constitutional courts as a part of the parameters they will use in constitutional adjudication. And this is interesting because it's a form of recognition of the maturity, to a certain extent, of part of EU law. Let's think about what the Italian Constitutional Court stated in Judgment 269 a few years ago, talking about a constitutional stamp of the Charter. There is a sort of compensatory function that the EU is playing with a lot of limitations, but still it is playing in states in which the rule of law is wavering. Finally, there is also a layer of legislation developed in a series of topics like data protection or equality, which is of substantive constitutional content. And it's making more concrete the generic commitment that we find in primary law to a certain of rights. Now, if we take all these things together, I think we find the European Union much closer to modern constitutionalism than it used to be 30 years ago or more. Now, all that said, therefore, what we have is a problem of coexistence of constitutional claims. To try to understand the problem, what I did was initially to look at the existing literature on constitutional pluralism, which is massive, in some cases excellent, and still left me with a sense of dissatisfaction. Why? Well, because if we take constitutional pluralism as a scholarly movement, as an academic movement, it is, in my view, for the most part, a normative movement, in the sense that it is made of scholars who more or less all share the idea that this state of affairs, the coexistence of constitutional claims at the EU and national level, is a good thing. It's an instantiation of constitutionalism in the 21st century. It's a first form of constitutionalism beyond the state. So it's a desirable state of affairs. And in case of conflicts, what do we do? Well, we will develop a set of principles, of legal principles, that will guide legal reasoning to solve it, to prevent it more likely. If we have a respect by apex courts in member states and by the Court of Justice of a series of principles, subsidiarity, proportionality, what we will have is, at the end of the day, no conflict at all. I'm thinking mostly about scholars that have been reflecting deeply about possibly applicable principles like Matthias Kuhn, for instance, or Poyades Maduro. And so this is the kind of, I believe, dominating narrative in constitutional pluralism in scholarship. A normative position and general principles of legal reasoning to dominate possible conflicts. I didn't appreciate that answer particularly. I always had the feeling that in the end, the answer to conflicts must be political rather than legal, and that there is really no way to avoid constitutional conflicts indefinitely, no matter what tools of legal reasoning we use. So what I did was then trying to dig deeper and try to find someone who had elaborated more into this line. It's a matter of political bargain rather than of legal reasoning, the way to solve conflicts. I found, of course, something in the initial writings of the intellectual father of constitutional pluralism, that would be the Scottish scholar Neil McCormick. The writings between 1993 and 1995, which are usually referred to collectively as the essays on radical pluralism. And of course, the title of the book is a clear, let's say, an attempt to connect directly this work to McCormick's Si parva licet. This is an attempt of continuing that inquiry 30 years later. Now, McCormick's theory of radical pluralism is quite complex. There is an entire chapter of the book, chapter 3, devoted to that. I will not enter into the details of that right now. I would just say that I found the later McCormick on pluralism less interesting, less satisfactory, and I think in the end contradictory. While the first essays, I felt they were much more promising. There is a couple of takeaways to extrapolate from them, which I then tried to develop later. First, the idea that radical pluralism, that constitutional pluralism is not necessarily, and was not initially, a normative enterprise. It can be a descriptive attempt to try to understand this coexistence of constitutional claims in Europe. Second, that the coexistence of various constitutions altogether, or in the Hartian vocabulary that McCormick uses, several rules of recognition, is possible, and it's actually structural. We always have a series of rules of recognition at play in every given legal system. And third, that constitutional conflicts are, as a consequence, inevitable, but they are usually handled via political negotiation rather than via legal reasoning. How to develop such account? Well, I've tried to do two things. One was to look at other cases beyond the system of the European Union in which we might find a similar scenario. So uncertainty on the ultimate constitutional norm, conflict, and how were conflict handled. And that is the object of chapter 4. Specifically, I've worked mostly on the case of the antebellum United States, so the system of the US between 1787 and the Civil War, so 1865. Later, I think it becomes a different beast, but before that, there are interesting similarities. And after that, besides the case of the US, also a series of unitary states in which I think it can be shown that there is conflict on the ultimate constitutional norm, despite them being unitary states. As for the case of the US, one can see that before the Civil War, a series of questions were deliberately left open. The question of sovereignty, because of the prevailing Madisonian concept of sovereignty as accepted back then, was equally split, or at least not clearly settled whether it belonged sovereignty to the states or to the federation. the question of the existence of an American people itself was not ultimately clarified. It was not obvious that there was such thing as an American people rather than the peoples of the various states. And despite the existence of such deep uncertainty, the antebellum United States remained a broadly functioning legal system for about 70 years. Once I checked, it was longer, this period of existence, than the entire duration of the Soviet Union, and much longer than many other unitary states as well. During that period of broad functioning, there were occasionally constitutional conflicts. I analyzed all those that I was able to spot in the book, and I think that what is possible to draw from the analysis of such conflicts is the conclusion that they were indeed handled politically rather than legally, usually by political actors, so parliaments and governments, rather than by courts. I also then, as was mentioning, consider the case of a series of unitary states, the Netherlands, Israel, even the United Kingdom, in which I give some examples of conflicts, constitutional conflicts on the interpretation of the Constitution, trying to show that even when you seem to have a single constitution, a single settlement rule, interpretive conflicts cannot be avoided altogether. Conflict on the meaning that such settlement rule, such document has. And therefore, the idea of completely removing constitutional conflicts from the horizon is unlikely to work even in unitary states. And then finally, in chapter 5, I try to look at the context of the European Union and specifically at the constitutional conflicts we experienced there in the last decade, more or less. I think it is possible to show by looking at these conflicts that, again, it's the political factor that dominates. First, I introduced the Taricco saga from Italy, which is a case in which apparently conflict was avoided by a dialogue between the Constitutional Court of Italy and the Court of Justice of the EU, but really, maybe what happened there was careful political reasoning by the Constitutional Court, careful judicial politics, and therefore, let's say it's not that much the principles of EU law and national law applicable to the case that dictated the outcome, but rather these clever techniques of negotiation. Perhaps we can return on that later into the discussion. And then if we look at the cases in which instead conflict was not avoided, and we had what we call ultra vires cases, so declarations in which apex court of member states declared EU law stepping beyond its attributions, its conferred powers, what we find is that they were constantly then solved in 3 out of 4 cases by political actors. These are the cases of the Czech Republic, Landova in 2012, of the Danish Supreme Court, IUS 2016, and then even the much commented PSPP cases of 2020. It was the role, again, of political actors that ultimately solved conflict. I also argue that these 3 cases are part of a sort of physiology of European constitutional law, given this extremely, let's say, pluralistic scenario, quasi-federal scenario. It's more likely that we will have conflicts than in the case of more unitary states. And finally, there is one last case of ultra-vires which I analyze in the book, and that is the K321 case from Poland, and that is most likely not a case of physiology, but rather a case of pathology, not meant in a normative sense, not trying to adjudicate which one is a good case of conflict or a bad case of conflict, but rather on the likelihood of breakdown of the law of the European Union that they entail. The first 3, I don't think they really ever meant realistically the possibility of a large-scale ineffectiveness of EU law in Germany, Denmark, or the Czech Republic, or not to mention the possibility of an exit from the Union. The case of Poland is a little bit different because of the context in which it happened. It's a much more conflictual scenario. It's part of the rule of law conflict that has been ongoing for 10 years now. And there, there is really the possibility of a large-scale ineffectiveness of EU law if conflict of such magnitude keeps going in the future. So I will not speak any further because I see my time is running out. Just to give a couple of let's say, final remarks. As a bottom line, first, my conclusion is that this structural plurality of the Constitution is just a fact of modern constitutional law. There is no way we can completely get rid of that. In the context of the EU, it's just much more evident. Second, conflicts are structural as well as a consequence, and they cannot be solved via legal reasoning. Only in most cases it would be political negotiation to be decisive. So as a result, really, this book is mostly about a book about the role of politics rather than law, and perhaps even an invitation of lawyers to let's say, realize the limits of their capacities and of their roles. Thank you so much for your attention.
Thank you so much, Orlando, for the presentation and for delving into the content of your book. I will now give the floor to Marco for the first session of comments.
Great. Thanks a lot, and thanks for the invite. It was a great pleasure, actually, to have the chance to read Orlando's book, which is rich, sophisticated, and rather insightful, I would say. Now, I take it that the duty of a commentator is obviously not just to praise the book, but to try to push the author to see whether the whole argument is consistent, is watertight, and what could be potential developments in the future of this type of approach. I mean, I have to say, and I have to confess from the very first moment, that I'm very sympathetic to Orlando's take on, in general, on constitutional pluralism. First of all, because he gives it a clear political spin. So his starting point is something that, or is a kind of starting point that I'm very much sympathetic to, because it basically implies that if there is a constitutional conflict, ultimately the answer tends to be mostly political rather than legal. And I think in this way, all the richness of political rationality and political reflexivity is actually, I wouldn't say liberated or emancipated, but it's definitely not exhausted by that machine, of the capturing machine that is usually the deployment of legal artifices, and especially, I must say, the judicialization of constitutional conflicts. So I have to say I'm really extremely sympathetic to this type of approach. Now I want to focus in my intervention, once I've already put basically my stance on the table, I want to focus on 2 points in particular, which I will simply ask Orlando to reflect upon and to see where he sees himself. Well, first of all, the title of the book, and in general, I would say at least chapter 3, but also partially chapter 4, seems to hint to the fact that the type of constitutional pluralism that he has adopted and that he wants to expand has a radical character. He takes it from McCormick, he has already explained it to us now during the introduction, which type of, or which phase of McCormick's thought he has deployed. But I have to say that when I think about constitutional pluralism, even in the McCormick sense, it's very difficult to imagine that it is something that brings with it a certain level of radicality. In the sense that usually, I mean, I would say that there is still some sort of a koine between different type of legal orders, which is what makes it possible to have a common register, which is the constitutional register, which is something that is usually not fully available when you really adopt a radical stance on pluralism. So the type of, I would say, Nico Krish approach, for example, to pluralism, which is clearly, in my view, a clever argument against constitutionalism and against constitutional pluralism, precisely because it doesn't want to admit that there is some sort of common frame, and I would say even more than that, a common language. And my feeling is that you seem to concede that there is ultimately a common language, and you seem to concede it when you examine the Polish case, in my view. But more on this at the end of my intervention. But this is a crucial point for the whole enterprise, no? So what is exactly radical about constitutional pluralism? So my feeling is that, first of all, from which perspective is the radicality observed? Is it the radicality here observed from the perspective of one of the participants to the potential of constitutional conflict? No? So take, for example, your main focus, which is the European Union. Are we observing here the radicality of constitutional pluralism from the perspective of member states, from the perspective of regions, from the perspective of the European Union? Or are we observing the radicality of constitutional pluralism as external observers? I'm not so sure that you would adopt the latter stance, given that you seem to rely so much on certain pages of Hart and the influence of Hart on McCormick's radical legal pluralism and constitutional pluralism, given that all of this makes sense and somehow relies, in particular the Hartian position, on an internal perspective and an internal point of view, which seems to me somehow carries, and it is brought actually into the picture implicitly by some of your pages, in particular again on chapter 3 and in the section on chapter 4 where you discuss, in my view, really insightfully, is one of my favorite sections of the book, and I've learned a lot on the South African case that Hart discusses at pages 122 of the concept of law, and which I have to say, thanks a lot for having highlighted it, because it's very helpful also for when I will be teaching next year, where clearly you reconstruct the South African case there from an internal perspective. It's the perspective of South African officials. This is where the political disagreement takes place, actually, and is really relevant. And what makes it really relevant as a kind of a constitutional conflict. But then my question would be, so what do you mean really here by radical? Do you mean that there is no ultimate authority? But if it is an internal perspective, I doubt that this can be the case. Because if there is an internal perspective and if there is a social practice of thinking about it, then I seriously doubt that there is no ultimate authority, or there is at least no authority for adjudicating this. Or, on the other hand, it is truly radical, and it means that basically in the presence of conflict, we cannot really identify. The very notion of authority is basically at stake. But then my impression is that I'm not so sure whether you can hold the commitment toward legal positivism. I cannot imagine a form of legal positivism that is not premised on the creation, the emergence of a legal authority, most of the time a centralized type of legal authority. So I guess that my question there is that, are you sure that you can have the cake and eat it as well? Being at the same time a radical constitutional pluralist and a legal positivist, and having both McCormick's first phase of pluralism and the Hartian conception of social practices and social facts as the ground of legal orders. My impression is that ultimately, and I will explain this why, I'm not so sure whether you are really committed to a radical form of constitutional pluralism. You are more committed, in my view, to a political form of constitutional pluralism, where there is a certain level of plurality of opinions, that and there is also, I would say, a wisdom, that's how I would call it, a wisdom of political practical reasoning that can be deployed in order to address things that are basically given by something that is, in my view, hovering or looming in the background of your discussion, which is the idea that we are talking about a high level of complexity here. These are constitutional conflicts that unfold in the context of an enormous amount of complexity. And therefore, the law is always somehow lagging behind. And that's why my impression is that you say, well, look, ultimately, when these things are solved or are somehow addressed, they are because we have resorted to political means and political prudential approaches. And that's why, I mean, I'm undecided about this, so it's a genuine question. No? But my feeling is that you cannot be at the same time that type of radical legal pluralist that you claim to be at the beginning, and then in the middle to unpack constitutional pluralism in a way that is somehow, I would say, fully political, at least in the way it understands how to address ultimately and solve, or somehow at least contain conflict. The second point is that for such a political conception of constitutional pluralism, if I'm correct, because this is a big if, I find it quite remarkable the amount of time that you spend looking into ways through which apex courts have actually addressed constitutional conflicts. I mean, there's nothing wrong in itself, and I appreciate a lot your remark in chapter 5, where you notice that, well, look, let's be honest, one of the reasons why in these 4 cases that I'm looking into, so the 5th one is the exception, is the Polish case, but in the other 4 cases, what happens is that there is intervention of some sort of political wisdom, either directly by the apex courts, but also through informal dialogue with other institutions, namely, say, in the PSPP case, the ECB. Fair enough, but I think it would have been probably, or it would be interesting to hear whether and how non-judicial institutions deal with constitutional conflicts in a context of constitutional pluralism. That would have been also quite interesting, and I think it would have served your argument, or would have made it even stronger. But when it comes to the analysis of the cases, there is something that again strikes me as I would say slightly underdeveloped. You seem to assume, and I would like to know exactly from which point of view you can have this assumption, but you seem to assume that there are healthy and pathological ways of dealing with constitutional conflicts. No? But my question here is that, well, hold on a second. So if we are a radical constitutional pluralist, how are we going to draw a distinction between the pathological and the non-pathological? Now, what is the threshold that makes a way of framing first and secondly addressing a constitutional conflict pathological? Because, I mean, where do you find the standard? What gives you the standard to adjudicate whether, say, for example, Polish authorities were pathologically behaving vis-a-vis EU institutions on the rule of law crisis? Because if the rule of law in that case pivots, no? So that is what is at stake is the concept of the rule of law, and it pivots around a European Union conception of the rule of law, then I'm not so sure that we are really still talking about constitutional pluralism there, right? We are talking fundamentally about, I would say, the priority, at least, to say the least, if not the primacy, of one understanding of the rule of law, which is typically, that the rule of law that is advocated by the Commission is a typically, it's a typical product of European integration. It's not state-based rule of law. But that, fair enough. But my point would be, well, but if there is a conflict on how 2 parts understand the rule of law, and you would probably classify it as an interpretative form of pluralism, well, my question is that how do you know that the conflict is addressed pathologically? I don't see any other solution there, except that if you have already decided it's pathological, is that actually one of the 2 conceptions is epistemically superior to the other. Because how do we know that the way I'm pretty sure that there are plenty of lawyers out there that would say that the way the German Constitutional Court fundamentally withdrew ultimately from challenging the European Court of Justice and the European Central Bank was pathological. There is an understanding of that conflict which makes it pathological. It clearly depends on the point of observation of the conflict, in my view. But this it really puts at stake the type of pluralism that you're adopting And in the Polish case, my impression is that without clearly wanting to defend the Polish position, but if we are radical pluralist, it is very difficult to imagine that we frame the type of conflict as a matter of, as a cognitive matter on who gets it right on the content of the rule of law. Because if we adopt that, then we are back to basically a classic liberal form of constitutionalism, in my view, where there are certain principles and around which and around whose, what you call fundamental core content, we actually all agree. But then if this is the case, but maybe those conflicts are not actually so harsh and are not actually so troubling, no? While clearly, as you clearly show, the case there is that things escalate because there's no political will. There is no political will to find and to negotiate and to bargain. There's no political will on both sides, fundamentally. There's the Polish non-political will, absence of political will to concede what counts as the rule of law, and there's the European Union political will to fundamentally spread their conception of the rule of law across all member states, which makes a lot of sense from their perspective, and don't get me wrong. But that's, in my view, is not constitutional pluralism, right? So, so I guess this is just to say that fundamentally, and to ask you, well, how do you define pathology there? Is it still, is pathology there a concept that is compatible with, and a standard that is compatible with a pluralist understanding of these constitutional relations? And I think I will leave it here, although there will be plenty of other things to discuss, but we will have time for the discussion. But great book, I have to say. Really a lot going on.
Thank you so much, Marco, for your comments. And I will now give the floor to Thomas for another 15 minutes of insights and comments on Orlando's work. Thank you, Thomas. You have the floor.
Thanks very much, Silvia, and thanks for chairing. Thanks everyone for coming. Thanks Giuseppe for inviting me. Thanks Marco for your comments. And most importantly, thank you, Orlando, for writing such an important and I think perceptive and rewarding book. I'd like to begin with my favourite sentence in the whole book, which opens chapter 4, where Orlando writes that constitutional pluralism is puzzling and irritating. I agree, and thankfully for us, Orlando's book is neither puzzling nor irritating. Now, I think pluralism is puzzling for precisely the reason that the author identifies and calls the riddle of pluralism that we've heard about tonight. How can it be that a legal system has two constitutions on top? That's what makes it puzzling. What makes it irritating is that as constitutional lawyers, we have been trapped for centuries in what Orlando calls the standard theory, developed by thinking about states, whereby any norm must be directly or indirectly reduced to a single unifying norm at the top of the pyramid. And I think it's this puzzling and irritating nature of constitutional pluralism that has always interested me. It's the itch that can't be scratched. It's the pebble in your shoe that when you take off your shoe to try to shake out the pebble, you can't find the pebble, it disappears. And I was interested to hear you, Orlando, saying that your interest in this goes back to your undergraduate days, trying to reconcile these two different ideas. I feel exactly the same way. I heard one thing in my constitutional law module, I heard another thing in my EU law module, and I was trying to work these out, and I'm still trying. It's this puzzling and irritating nature that is, I think, part of the explanation for the bifurcation in the discipline between the radical and the normative elements of constitutional pluralism and the dominance of the normative conception. So Orlando writes, and I think he's correct, that the focus of normative pluralists is on interpretive methodologies that the main legal actors use to preserve the suspension of the question of ultimate authority without colliding, to save pluralism. Now, I think Orlando has done us a valuable service by mounting an explanation and a defense of a specifically and explicitly radical conception of constitutional pluralism, one that is descriptive, not normative, realist rather than idealist, and political as opposed to juridical. As we've heard, Orlando points out that the riddle, in fact, isn't a riddle at all. plurality of foundational criteria is possible and normal. It's not paradoxical. And the EU is just a more obvious expression of this than in other systems. Now, my own thinking historically on constitutional pluralism has been very firmly in the normative camp. And this is for two reasons. First, because the ever-present possibility of conflict always embarrassed me in a theoretical sense. And it also worried me in a political sense. And I think one of the great triumphs of Orlando's book is that it has very much lessened my theoretical embarrassment about the open-ended nature of radical constitutional pluralism. How McCormick wrote, which, as McCormick wrote, entails acknowledging that not every legal problem can be resolved legally. And I'm aided in being freed of this embarrassment also by the work of Signe Larsson, on which Orlando draws, in which she demonstrates the poverty of the dichotomy between Bundesstaat on the one hand and Staatenbund on the other hand, and instead sets out her conception of the federation, that is a federal union of states, which is not a federal state in itself, and which neither the federation nor the states are fully sovereign. And this is where my first question arises for Orlando, in that in your discussion of Larsson's work, you question her latter position, that neither the federation nor the states are fully sovereign. And you use your analysis of the antebellum United States to write that, quote, sovereignty was considered a concept fit to define the union that was instituted, although conceived as divided and dispersed, rather than united and indivisible. I confess that I detect perhaps some kind of contradiction, or at least an uncomfortable juxtaposition between this and your earlier analysis of McCormick's radical pluralism. In McCormick's combination of a legal notion of sovereignty and a political notion of state, McCormick came to the conclusion that a sovereign state is a territorial political order coupled with a legally defined position of near absolute legislative power. Now, it could be that I've missed something, and it may well be the case, but it seems to me that McCormick's definition, that he was trying to go beyond and beyond the sovereign state, owes rather more to Hobbes and Rousseau than it does to Jefferson or Madison. And that your own analysis of the antebellum United States does perhaps overstate the extent to which your conception of affairs differs from the conception of affairs offered by Signe Larsson. So that's the first issue. My second issue is related, and it's about the question of collapse, seeing as we're dealing with the antebellum United States. I said above that my theoretical embarrassment about constitutional pluralism has been lessened or perhaps resolved by your work, but my political worries have not. Now, this could be a failing on my part, a kind of jurisprudential centrism or triangulation, whereby I try to extract from incompatible theories a synthesis that solves all my problems. Now, you write in the book correctly that just because the German Confederation or the antebellum USA later coalesced into federal states, that doesn't mean that federations are inherently unstable and that they have to collapse into the only organization that provides stability, which is the state. Now, I think that's true. But could it not also be argued that that history of either coalescing into a federation, into a federal state, or disintegrating into nothingness, raises questions as to the necessity of a specifically normative theory of constitutionalism, and specifically of one of constitutional pluralism that can stave off such collapse? Is it not arguable that this very absence of a normative theory is one of the reasons for the historic tendency to either thicken into federal states or to thin into dissolution in the first place? So my question there is the one I've been wanting to ask since I first opened the book. Why is this account of pluralism described as being specifically radical? Or in your own words, what's wrong with normativity? Even if we accept that the riddle of pluralism isn't a riddle at all, and that plural sources of authority are perfectly unremarkable, is it not also the case that we could, maybe should, develop coherent theories for the management and resolution of conflicts? If not, why not? Is there something perhaps dangerous or pointless or simply uninteresting about doing so? The third question follows directly from the second, and shows perhaps a tendency towards triangulation. Is it possible to hybridize these theories? Can you synthesize theory that draws from radical pluralism, the sociological realism, the admission that not all legal problems can be resolved legally, but draws from a normative approach, the idealist notion that we can construct methods of interpretation and communication and practice that take the field of legal problems that can be solved legally and expand them, and take the field of legal problems that cannot be solved legally and shrinks them. Not into non-existence, it recognizes that some things are simply irresolvable legally, but tries to shrink that field to the truly pathological case. Now, Orlando writes in his, I think, very perceptive analysis of McCormick's shift from what he called radical pluralism to pluralism under international law, that the shift to pluralism under international law ultimately generated nothing but contradiction, because it attempted to combine a Hartian theory of law and a Pelsinian theory of relations between legal orders. Now, this is a compelling argument, but is it possible, perhaps by not combining these two conflicting approaches, to develop a synthesis? So in this context, I was fascinated by the analysis of the case law, and in particular of case K321, the Polish case. Now, it's exactly cases like this that the anti-pluralists, the Kellermans, the Pechs, the Vaquero Cruces, use to demonstrate what they think of as the poverty of both radical and normative constitutional pluralism, and their preference for what I think we can safely call a transformation of the EU into a federal state. And the key difference to me is the difference you identify between it and the other ultra vires cases, where in the other cases, the dispute is not substantive. It is, we could call it meta-constitutional. It's not really about cases of VAT fraud or compensation for laid off workers, or it's not even about the purchasing of bonds by the ECB. It's about how these norms of one system integrate into or don't integrate into the structure of the national legal system. By contrast, the Polish case is a direct challenge to the compatibility of primary EU treaty law. Do the given articles conflict with Polish law? And that question was asked in the abstract and not in the context of a concrete factual situation. There are similarities here with another case, the Hungarian Constitutional Court's decision 22/2016, where the government confected two questions of the court. Firstly, a concrete question about a council decision, which the Hungarian court said it would answer in another judgment, which then never appeared. Another question, a more abstract question about whether Hungarian institutions could review EU norms. And I think this tells us something interesting about the Hungarian and Polish approach, and I think what you call the pathological approach, something I've elsewhere called disloyal approaches. The answer in the Hungarian and Polish cases to the riddle of pluralism is that there's no riddle at all, because there's only one source, ultimately, of constitutional authority. Now, I wrote in 2021 that we need to develop a toolkit to distinguish legitimate and illegitimate dissent, to distinguish pathology from physiology, as you put it. And I propose that because I do want to keep open the question of the final say and provide safeguards against abuse of a pluralist system precisely in order to preserve the system. I don't want an EU federal state. I don't want the EU to disintegrate. So that's precisely my attraction, the form of the union of states. So am I wrong, and why? And finally, then, it is to do with your analysis of McCormick's blending of a Hartian and a Kelsenian approach. So you write that for Kelsen, if we could claim, it's about the postulate of epistemological unity. You write that for Kelsen, if we could claim that a norm is legal from the point of view of the state or from the point of view of international law, then there would be several points of view on law. And thus the epistemological postulate of unity would be violated and no science of law would be possible. I like to think about this in the context of constitutional pluralism as the campfire problem. It's an epistemic problem. When you're sitting around a campfire at night, the fire is very bright, and so you can't see your surroundings beyond the campfire. It's only when you stand up and step backwards away from the campfire that the surrounding forest comes into view, and you can see that there are, in fact, other fires with other people sitting around them, other epistemic communities, other legal systems. And for me, this goes right back to what Neil Walker said long ago about there being no about there being no Archimedean point, no freestanding perspective. And I question this. We can look at constitutional pluralist discourse as being epistemologically unmoored, or perhaps put less strongly, merely external, able to comprehend the claims of interacting legal orders without necessarily seeking to unify them, and conceptually comfortable with the idea of incommensurability, though perhaps uncomfortable with this for political reasons. Now, Orlando, you write that heart is the better of the argument here, and that recognizing that conflicting norms can arise in different jurisdictions doesn't stop them being valid norms. Now, I agree, but I wonder what this means for normative pluralism and for radical pluralism. Does the rejection of the postulate of epistemic unity and the adoption of a more relativized external approach, does that go any distance towards remedying your objection towards the normative approach? Now, in truth, I do have hundreds of other questions, but time is not on my side. Like Marco, I particularly enjoyed the forays into the Israeli, UK, South African cases. I think I do remember having a disagreement with your interpretation of the South African case in one important respect, but I neglected to make notes on it at the time. So perhaps we can have that in the discussion. But I would like to close by again thanking you for the book, congratulating you on it, and congratulating also those of you here who have yet to read the book, because you've got a real treat in store. So that's, I think everyone who hasn't yet read the book has something nice to look forward to, which is always something nice. So with that, I'll close and thank you, everyone.
Thank you very much, Thomas, for the exhaustive contribution. And for now, I would ask Orlando first to see if he wishes to reply to the questions and comments, and maybe we can open the floor to other participants in the public. Please, Orlando.
Thank you, Silvia. Thank you a lot to both Marco and Tom for their extremely kind words. And also for the avalanche of comments and questions that I just received. I will do my best to try to answer at least some of them. I hope you will be, pardon me if I'm not able to answer them all exhaustively. Perhaps then there will be time afterwards to discuss them more properly. Starting from Marco's point, on the first, can constitutional pluralism can ever be radical, and what do I mean by radicality? First of all, I don't mean, of course, radicality in a political sense, in a sense of, let's say, fringe faction within the political spectrum. This is, of course, I think a given for whoever has read the book or knows in general the debate on pluralism, but just for to clarify with the audience, it's not that. It is, I think, what Hart would call the external point of view. It is a perspective on the social facts that make for European constitutional pluralism that try simply to register the claims made by the various actors. According to the German Constitutional Court in Maastricht, the ultimate source of authority is in the Constitution. All the rest is an association of states validated by the German Constitution, and so on and so forth. And if one takes opinion 13, one finds a completely different narrative concerning the autonomy of EU law. And if one looks at cases like Granital, another one, even a third one, let's say a different one. And this is why I wanted to spend some words on each of them in chapter 2, to show that there can be different narratives, that's what they are eventually, on the state of legal affairs in Europe. Where does ultimate authority lies, and what are the consequences of that? And the perspective of someone who maybe embraces radical pluralism is exactly this one, registering these facts, try to make sense of them. The fact that they all happen within the common frame of constitutionalism, I don't think it has decisive consequences in one specific sense. Constitutionalism is, in a sense, a political theory accepted by all involved actors, but it is indeterminate enough or underdeterminate enough to allow for very different conceptions. It's, in a sense, the difference between a concept and a conception. The concept of constitutionalism is shared. Their conceptions are then quite different, and one can register this agreement. Perhaps it would be better to define this as a form of political constitutionalism. This might be. I've tried to stick to what I perceived as the, let's say, most appropriate interpretation of the early writings of McCormick, since those writings are usually labeled as the radical phase of McCormick or the radical form of constitutional pluralism in McCormick, then I appropriated myself of that label as well. Perhaps it was not a particularly good choice, but this is what I mean. It is indeed the external point of view. As for the time and space which I devoted to apex courts, I fully agree. It's something I am regretting a little bit today of the book, that I try to underline the role of political actors. I think that I do to a sufficient extent, in the sense that it's clearly specified case by case that political actors intervened in such and such manner. But I probably could have done more in that sense, focusing less on the reasoning of courts and more on the actions of governments and parliaments. It would have made, I think, the argument stronger. So I fully agree on this question / comment. But it was, let's say, it was too late at that point to do anything about that. It was published already. And then on the question on health, conflicts or pathological conflicts. This is another case in which I'm regretting the etiquette I have chosen, because I see it is it gives the idea that it's maybe a value judgment. Those conflicts which I label pathological have a positive label. Those that have the pathological etiquette, well, they're negative. That's not exactly what I meant. What I meant is the likelihood of a collapse. The likelihood, the probability that, given that conflict, in the long term, or perhaps even in the short term, what will follow is what Hart calls the breakdown of law and order. So in this specific case, what would it be? Perhaps the exit of Poland from the Union, or maybe less dramatically, at least a very, very wide disapplication of EU law in Poland, which to a certain extent might be already happening. So what's the criterion to distinguish? What's the threshold? An analysis of the political context, and then our best guesses on the future. If I take the political context in Landova and Ayers, and even on PSPP, which I agree has to a certain extent a weak legal reasoning, I've written on that as well. But I don't think there really was any significant risk that EU law would be vastly disapplied in Germany, or that, even more unluckily, Germany could leave the Union. There were quite fast attempts by political authorities in the following weeks to calm down all involved actors. And if you look at what happened in the following year, eventually it was really a political negotiation. One finds 1 year afterwards the Constitutional Court of Germany refusing to admit a case because the question had been solved in a satisfactory manner by the parliament, by the Bundestag. Poland is a different context. I try to give a few reasons for that. The K321 case was asked for by the government. More or less what they got was what they asked for. This happens because the court is an enabler. It's a completely packed court. There was no publication of the judgment until way more, until after 1 year. And indeed, I had to write the book not knowing what the motivation was. Not that I have lost much, apparently, but there was no opinion when I was redrafting. And as Tom was mentioning as well, the object is different. They're clearly, in the tenor of the judgment, attacking the general, let's say, the fundamental political principles of EU law, rather than the nitty-gritty of that directive or that regulation applicable to Poland. It's a clearly conflictual political context, and within that clearly conflictual political context, the likelihood of a pathological result, of a pathological outcome, increases dramatically. Now, of course, this is a matter, at some point, it's a matter of degree. There is no formula to decide once and for all which case is a case of conflict, which case is a case of, which case is physiological and which one is pathological. For instance, as you were mentioning, I think correctly, the German case might have been, at least at the beginning, perceived as in between. Then I think it was quite quickly, it was brought into the field of physiology by political actors. But this is what I mean. It's not a matter of value, it's a matter of fact, to the extent that I'm able to assess them, of course. As for Tom's question instead, so on Larson's view on sovereignty, my only take is that she argues, if I recall that correctly, that sovereignty is not a category applicable to unions of states. It's something born in the context of scholars, lawyers and philosophers like Hobbes, and it's simply unfit to describe cases like the Union of States. What I was trying to do is simply to say, look, if we take the own words of people clearly involved into the lawmaking, law application of the first case of the Union of States on which she herself relies, I think that's just not true. They would say that sovereignty exists in the context of 1787 United States, but it's split. All that said, I rely a lot on her book, and I find it a very interesting reading from which I've learned a lot. But on that specific point, I don't think I buy her argument. Is McCormick closer to a scholar like Hobbes than to one like Madison? Yes, I think you are right. And indeed, what I find in McCormick, and to an even minor extent in Hart, is the beginning of a reflection on the fact that perhaps sovereignty as they conceive them is not as unitary as it might be, as one might think. There are lines from Hart which I found and reported in the book in which he insists that perhaps in a federal state sovereignty might be divided. But if one looks at the entire essay, it's really a couple of lines. And then he goes on with the argument very quickly. McCormick is a little bit sophisticated on that point, but even so, beyond the sovereign state is, of course, a great essay on the topic. But even so, he never completely, let's say, crossed the line towards admitting the possibility of divided sovereignty. But in a sense, there were things in this approach which I found underdeveloped. Not sufficiently developed. There was some difficulty in dropping the premises from which they were moving originally, and that is, again, this is why I felt the need of trying to go until the ultimate conclusion of the argument. And whether the normative perspective is possible to be reconciled with a radical stance, I've been thinking on that myself. Maybe this can be done on paper. I find it extremely difficult then to do it in practice. Yes, as you were suggesting, it probably is possible to say, okay, so this is the state of affairs currently, these are the conflicts, these are the political actors at stake, and these are the political solutions that have been developed as a consequence. But they might have reason in such and such manner, starting from these principles extrapolated from the general conception of constitutionalism and from text, and avoided conflict in such cases, while in these others, well, there was nothing we could do. It was really a case of political conflict only. But then it's very tempting to try to solve everything via these conflicts we have identified. So maybe you're right, maybe it can be done. I still have to find a scholar that is really able then to stick to these premises and not then try to over-juridify and so legally what should be really left to political determination. But it might be, let's say, my limitations, which I superimpose on others. And this might be possible to do in practice. And lastly, what was the, oh, well, let's say the similarities between Kelsen's epistemological postulate of unity and the in normative pluralism. I think that there is something like that. There is a work which I found when I was researching this issue, in which, and it was signaled to me by David Dijsselhout, in which he, well, let's see, there are parallels drawn between Dworkin's theory of legal reasoning and Kelsen, in the sense that in the end, the practitioner must always have in mind a single ultimate norm to make sense of the legal materials. You cannot, as a practitioner, I would stress that, as a practitioner, not as a scholar, you cannot do your job if you don't think that there is ultimately one norm from which you're starting, which must work as a settlement criterion. I've never been fully convinced that Kelsen would buy this as an ethical argument, and he probably meant really something epistemic. If I don't start from a normative premise, I will fall into an is-ought fallacy, and my reasoning will collapse. But I might be wrong into this interpretation of Kelsen. So yeah, maybe there might be some similarities between Kelsen's epistemological postulate of unity and normative pluralism as it developed in the last decades, but I've never been completely sure on that. But I would be glad, let's say, to read your takes on this specific issue if you have one. I will stop here now.
Okay, thank you very much, Orlando, for replying to all the comments, or most of them. I am now wondering whether there is anyone from the public that would like to ask.
Orlando, for this presentation. I'm very happy. As colleagues in Leuven right now, I know a lot about your current project, but I didn't know a lot about your PhD. So very happy to attend this presentation. I'm not very familiar with literature on constitutional pluralism, so correct me if I'm wrong. I have some questions just to push you a bit more and to understand a bit more your point. So you say you interact with this literature which has as a dominative narrative that constitutional pluralism is a good thing and that we can solve these constitutional conflicts with legal reasoning. And so that the consequence is that actually there is no conflict at all. There are legal techniques to solve these conflicts. And you say basically that there are conflicts and these conflicts are normal and that they are unavoidable and we cannot solve them. And we cannot solve them with legal reasoning, but with political negotiations. So this is what I understood. And I have two questions related to that. The first one is there a normative claim in your book? Namely, do you think these conflicts that are unavoidable, as you say, are actually useful insofar as they push the political negotiations? Then if we look at the EU context, the EU has always been criticized for being court-centric. I wonder whether you consider that these conflicts are pushing more political actors, so as you say, parliaments, governments, institutional actors, to solve these conflicts more than the courts themselves, because in some cases, as you say, the conflicts are solved by judicial politics, and then what's the role of parliaments, governments, and other actors than courts? These are my questions. I don't know if they are clear, but thank you so much.
Thank you, Silvia, for sharing your thoughts. And now I'll give the floor to Nicola for the last question, and then to Orlando.
Can you hear me?
Yes.
Thanks. Thanks to all of you for your presentation. They were amazing, and I really appreciate the argument. Then, thanks very much for all this stuff. I have, I think, 2 remarks / questions. First of all, the first is about the political side. That is, I agree with Orlando that the problem of European Union should be solved under a political umbrella, and then to put aside the legal framework and the legalism that is the mainstream way to solve problem at European level. But I think that this is very, very problematic, because I was thinking about the PSPP judgment in light of the Next Generation EU judgment. That is, after the impeachment action brought by the Commission against Germany, Germany and the Commission, the German government and the Commission reached an agreement that when they defined as constructive misunderstanding. That is, where Germany and German government offers some strong commitment to European integration. But then, and after, we have Next Generation EU judgment, where the legal reasoning of the German Federal Constitutional Court was very problematic, because they said we don't raise a preliminary reference because our interpretation of the treaties is narrower than the ECJ. Then it will be unuseful to try for an interpretation by European institution. Then also the dialogue after a political solution, a political agreement, a settlement, it's very problematic. And then I am not sure that this kind of political solution could be good, but because also it is very contingent on the kind of party that is in the government. I was thinking about a hypothesis where the coalition was led by the Alternative for Deutschland. Then what will be the political solution to this question? I think to try to solve European integration under the umbrella of political compromise is good, or political solution is good, but we cannot rely on solution where there is a bargaining between a national government and ECJ or Commission. And then I was trying to this problem. And then the normative question, the second question is about what is at stake in the constitutional pluralism. The triggering of this pluralism was a clash about fundamental rights. But I am not sure that in a pluralistic view, we can protect better the fundamental rights. And I'm thinking to Melloni case, where DCJ tried to strike a balance between the fundamental rights and the relation between constitutional codes. And then I am not sure that constitutional pluralism could reach and settle very well the problematic that are at the basis of constitutional pluralism. That is the protection of fundamental rights, because the first case about constitutional pluralism was Solange the first, and where the protection of fundamental rights was at stake. Then I have these 2 remarks / question for you. Thanks.
Thank you very much, Nicola. Now, Orlando, I would say you have around 10 minutes for for replying, and I would invite also any other participants to raise their hand for a last round of questions in time. So please, Orlando, the floor is yours.
Thank you, Silvia. So trying to be brief for possibly allowing other questions. On Giuseppe's remarks, have pluralists changed their mind in time? I think they did. There is, as you were mentioning, a new generation of constitutional pluralists, which pointed their finger mostly on a distinction between good and bad conflicts. Sorry about this very poor terminology, but it's more or less what, to a certain extent, Marco was pointing at a few minutes ago. So how to draw a line between constitutional conflicts that we can live with, that we can accept, and constitutional conflicts which we cannot accept. You were mentioning Anna Bobic, for sure. I would say that Tom is part of this group of scholars. I don't know if he agrees with this characterization, but for sure there is, and it probably derives from a stronger awareness today of the inevitability of conflicts. Perhaps the generation that wrote before them was living in a context in which really macroscopic conflicts between states and unions felt like less likely 20 years ago, perhaps. But of course, today the situation has completely changed, and scholars have tried to keep up with it. I would like to stress again that this is not anyway the kind of analysis that I've tried to perform. It is not about distinguishing what is an acceptable conflict and what is not an acceptable conflict. I was just trying to point my finger towards what will eventually break the union, what will not break it, based on the existing evidence. On national identity and the role of Article 14.2 as an intimation of constitutional pluralism, I don't really have a completely clear opinion on that. For sure, it might seem to be like that, and most likely some courts have tried, at the national level especially, to use it that way as a justification for exceptions to primacy, perhaps as fig leaf in sometimes for pure politics. This has happened as well, for instance, in the Hungarian case that Tom was mentioning a few minutes ago. Was it born like that? I am not sure, based on the paper by Guastavero on the Yearbook of European Law. I would say it wasn't. It was mostly a clause on the exercise of competences at the EU level, and therefore not an embodiment of the idea that there are conflicting constitutional claims and that we recognize their diversity. But let's say these two narratives might be true simultaneously. The drafters meant something, and then the practical application meant something completely different. One interesting thing is that so far, at least, national identity has not been the justification for the, let's say, real derogations from EU law, cases in which the court says, and therefore, based on our national identity, we will not, in this case, apply EU law. It has always been so far ultra vires. It was mentioned, yes, in PSPP. It was mentioned also in K321, because in my reading, it is an ancillary argument with a minor role to play. The core of the reasoning is all on the conferred powers of the union and whether the union overstepped. And perhaps this is the long shadow of Maastricht, of the Maastricht Urteil, rather than of constitutional identity. That is perhaps the judgment which really gave the intellectual tools to later courts to perhaps establish when EU law was to be disapplied internally, based on internal considerations. I'm not sure I got exactly your point on Landova. Sarmiento's point would be that PSPP is different and worse than Landova, or they're out
yes,
of...
yes.
Yeah.
What do you think about that?
Okay, I have the feeling that our, but this is more a feeling, that our attitude towards PSPP is particularly negative because of 3 reasons. First, the object. we cannot really compare the political, the economic plans of the European Central Bank on a continental basis and for many, many years to these pension schemes for a certain number of Czech citizens, or in the case of AUS, to controversies in labor courts in Denmark. We have been all attracted by the magnitude of the object, but this doesn't mean that the legal reasoning per se was worse. Second, it's the German Constitutional Court that pronounced that statement, that issued that judgment. And because of the role that the German Constitutional Court traditionally played and still plays in terms of intellectual, let's say, primacy, it's difficult not to be captured again by whatever the German Constitutional Court writes. And third, Honeywell, the fact that there was a judgment in which the German Constitutional Court assured that they would not review EU law, if not in macroscopic cases, and then what they did felt like something different, that it was not that macroscopic, that case after all, and still they declared the case contra Davides. So my take would be that it's not that much worse than Arios, for instance, or than Orlando Vam. But there are contextual reasons that made it much more problematic, or at least perceived as much more problematic. That would be my take. On Ilaria's question, is there a normative claim in my book, and are conflicts useful? They push political negotiation. Honestly, no, there was no normative claim in my book. I wasn't trying to make one. Perhaps it can be their own. It's always possible to extrapolate normative claims with enough thinking, I believe. But no, I didn't have anything like that in mind. Then on the fact that constitutional conflicts push political negotiation and perhaps change, that might be true. Giuseppe is a great, let's say, he points his finger towards the role that conflicts can play, that of a certain engine of constitutional transformation. This might be, but it was not my intention to make such statement. And on whether what to do with cases like Tarico in which the negotiation is judicial rather than political, simply, again, realize that this is what happened, that there are cases in which judges play with politics in a very subtle sense. I think that Tarico was a masterpiece in that sense, especially because they showed to the Court of Justice that there was an honorable way out, right? If one reads the 2017 order to the Court of Justice, they say, so there are internal reasons why, including constitutional identity, which push us in this direction. We cannot accept a procedural conceptual limitation period, sure, but be mindful that your own legal system gives you the tools to accept and to justify this conclusion. Article 2, Article 4.3, a certain interpretation of the Charter, etc. And I mean, this is playing with politics. They might have not mentioned such provisions, and perhaps the argument would have, the outcome would have been different. We will never know. I just wanted to stress by analyzing that case that politics is something that, sure, parliaments and governments and political institutions do in the first place, but judges are not exempt from that, especially when they are apex courts. And on Nicola's remarks, political solutions are contingent, yes. It would have been different and perhaps worse if a different coalition was in power in Germany when PSPP was decided, maybe. But I would have on that two takes. One derives strictly from my book, and it is that there's not much we can do about that. So the mere fact that political negotiation might generate unpleasant results is not a reason to deny the fact that, well, in most cases, it is political negotiation that in any way is the only way out, because there are simply no legal principles applicable. And these strictly derives, I think, from a book. The second take does not derive from a book, and it's let's say external and derives merely from a possible, let's say, political objection one might make. Yes. So what? I mean, what do we do if an unpleasant coalition surges to power in one of the member states? We will ignore their political takes on conflicts with the European Union. Can we do that? Is it democratic? Is it fair? I realize the risk you're underlining, but again, it's a matter of political will, as it is in the case of Poland. There are limits to what we can do in that cases as well. And on the question of possible danger of fundamental rights that constitutional pluralism might generate, I think I agree. There's a lot of scholarship on how much this sort of competition between different authorities on the same group of fundamental rights will eventually generate a better outcome, but it's not a given, absolutely. Maybe Melloni is not that fair as an example, because there were also reasons there of harmonization that had to be taken into account, and indeed then the following cases seem to point towards the fact that when such harmonization is not strictly required and there is more room left to member states, they can apply their conception, their specific national conception of fundamental rights without the Court of Justice overreacting. But besides that, I think I agree with your observation. It's not a guarantee of anything in practical. And I will stop here.
Thank you very much, Orlando, for the very exhaustive answers that you give to the comments and to the questions. If there are no further questions, then I would stop our session here, and I would thank everybody who intervened, starting from Orlando, of course, and then for the discussants, Marco and Thomas, and of course Giuseppe and all the STALS team for organizing this. Thank you so much. As I can say, as an external observer, it's been a very enriching conversation, and I honestly think that these issues, a bit very theoretical, can be of great interest also for practitioners like me that work a little bit on the crossroad of several legal systems. I will be happy to further discuss with Orlando here in Brussels if we have the chance. So thank you so much, and well, have a lovely evening, you all, and hope to see you next time.